Hello, everyone. Welcome to this session on patent agent exam paper 1 solution for 2011. We have been conducting these sessions since last few days, wherein we are discussing paper 1 for various question papers for patent agent examination. On the Pharma Literati YouTube channel, you would see the answers along with explanation for paper 1 of patent agent exam of 2018, 16 and 13. So this is for 2011. In this part A1, the first part is of 40 marks, requires you to pick the right answers from amongst given choices. This part consists of multiple choice questions and true and false. You must all answer questions in this part. If there are two good answers to a question, you must choose both. That is, if for question 1, if the correct answer is C, you must write C. But if question 1 has two correct right answers, B and C, then you must indicate question 1, B and C. So if there are multiple correct answers, you have to choose those multiple correct answers. In the above example, if you pick only B and not C, then you will lose half of the marks. However, if you choose a wrong option, so for example, if you choose A, B, C, in that, then you will not get any marks. So that means you have to select the correct answers first thing, whatever number of correct answers are there, and if you select any wrong answer, then you would not get any mark. But if there are two correct answers and if you select one correct only, then you would be getting the mark proportionately. That would be half. So the first question is, a patent application means, and the options given are provisional application, complete application, application published before grant, patent of addition, application of patent of addition, an application which is accompanied by a sample, and all of the above. The correct answer to this is A, B, C, because a patent application means a provisional application is also called as a patent application, complete application, as well as any application published before the grant, that is also patent application. After grant, it is actually called as a patent. So the correct answers are A, B, and C. Now, the term of a patent of addition filed on 7th January 2006 and it got granted on 15th Feb 2009. The main invention was filed on 23rd August 2005 and granted on 30th October 2008. Now none of the patent is revoked basically. Okay, that's what the bracket mentions. Now in this case, the term of a patent would be 23rd August 2005, because in case of patent of addition, the term of the patent is equal to the main invention, and the main invention was filed on 23rd August 2005. So 20 years from that would be 23rd August 2025. Now the central government is empowered to revoke patent in public interest. The options are after moving the appropriate court, after hearing the patentee, after issuing necessary compulsory license, after appealing in IPAB, after allowing post-grant opposition, and none of the above. The correct answer is after hearing the patentee. If you go to section 66 of the Indian Patent Act, the central government has power to revoke the patent in public interest. But then the condition therein is that you have to hear the patentee. There has to be an opportunity for hearing to the patentee. Next, question 4. Register of Patents will contain, what does it actually contain? Name and addresses of the grantees of patents, assignment and transmission of patents, notice of trust affecting patent, infringement proceedings on the patent, opposition data on the patent, and all of the above. Now, register of patent would contain name and address grantees and assignment and transmission of patents. This, if you go through section 67, which is about the register of patent, these two things are actually covered in it. A patentee whose patent is lapsed and restored. So restoration of patent is a term wherein the patent, granted patent, gets lapsed and later on restored. Now, in this case, the patentee can file a suit of infringement during the period of lapse and restoration, license after restoration of the patent, bring an injunction during the period of lapse and restoration. Now, only be entitled for royalty during the period of lapse and restoration, all of the above and none of the above. Now, in this case, I'll go with the elimination criteria. I would say I'll try to eliminate the options basically. So the first option that I would eliminate is so during lapse and restoration, basically, once the application, the granted patent is lapsed, let us say without because of not paying the maintenance fees. In that case, during that time, you don't have the right, so you cannot file a suit of infringement. So that is a wrong answer. During that time, you cannot also bring an injunction because you don't have the right, and you cannot go to court enforcing your rights basically. C is also wrong answer. D, only be entitled to royalty during lapse and restoration. So you don't have rights, how would you get a royalty out of it? So I have eliminated A, C, D. Okay. Now, of course, all of the above is wrong because all these are A, C, D are wrong. So A, C, D, and E are the wrong options. Now, only two things are left: license after restoration of the patent, or none of the above. Of course, any one of these two is correct. And the correct answer in this case is license after restoration of the patent. The moment your patent, so restoration brings back all your rights of the patent. So you can license it out, you can file an infringement suit, you can bring an injunction, you can also be allowed for a royalty, but this would be after the restoration. But during the lapse and restoration, it won't be available. Now, compulsory license for export under Indian Patent Act is allowed for pharmaceutical products only. If you go to section 92A, we are speaking about compulsory license for export actually. So if you go through the entire chapter compulsory licensing, most of the things are local actually, but for export it is allowed only under pharmaceutical products under section 92A. The other option given: diagnostic kits, medicinal plants, clinical trial data, genetic modified microorganism is like, and diagnostic kits basically. So like, all these are wrong options. The correct answer to this is pharmaceutical product. Now, a patent infringement case should be initiated only in, now you've given 6 options here: district court, high court, IPAB, International Court of Justice. All of the above, none of the above. Let me again, try to understand, try to tell you, I can eliminate few options basically herein. When we say a case, infringement case, it has to be in court basically. So IPAB is a wrong option. That means all of the above is also a wrong option. Then the International Court of Justice. If I know that patents are jurisdictional rights, so Indian patents are only restricted to India, the case can be only filed in the Indian court. So D is also a wrong answer. C, D, E are wrong. Now remained is A and B. And if you go through section number 104, the patent infringement case can be initiated in the district court or high court actually. Okay. Now, question number 8, once a compulsory license is granted, you're given 5 options. Terminate, it can be terminated by the controller. License holder has to be heard. Termination only on valid grounds, all of the above and none of the above. The correct answer for this actually is a bit tricky, because here in all of the above bold, right? So A, B, C, and D. So it can be, the compulsory license can be terminated by a control. It like, in this case, the license holder has to be heard basically, as well as the termination is only valid only on the valid grounds actually. This comes under section 94 of the Indian Patent Act. Question number 9, when a biological material has been mentioned in the patent application, it must be deposited with the IDA, International Depository Authority. So we have 5 options here. When specifically requested by the patent office when the applications come up for the examination. When it is not capable of being fully described in the application. When it is not easily available in India. And the 4th option is when applicant finds it will aid in convincing the patent office of the patentability of the invention containing the material. And the last option given is all of the above. In this case, the correct answer is when it is not being capable of being fully described in the specification, and when it is not easily available in India. So this is, if you go to section 10(4), 10 is about the entire contents of a specification. 4D, if you go, then these 2 things are specifically mentioned actually. So in India, we have 3 separate depository bodies. Also remember that it is not necessary that the deposition has to be only with the Indian depository bodies. If those microorganisms cannot be deposited at any of the Indian depository bodies, in that case you can deposit it outside as well. Question number 10, in post-grant opposition, the person opposing shall submit a copy of the statement of opposition to patent office, copy to the patentee, notarized copy of the evidence through registered post with acknowledgement due, and all of the above. Now the answer to this is all A, B, C, D, E actually. This is under if you go through the proceedings, the section 25(2) actually for the post grant opposition and the matters related to that and the concerned rules, then you would see that all these things are correct actually in case of post grant opposition. Question number 11, when submitting a patent application, the drawing should be in 3 dimensions if it relates to a molecular structure, A4 size sheet without descriptive matter in the drawings except the flow diagrams. We also call it as a flow chart basically, without colors and none of the above actually. So the correct answer is A4 sheet and without descriptive matter. You are not allowed to put any descriptive matter, drawings and the flow diagrams actually. That is what, and this is as per rule 15, the way the drawings have to be actually submitted. International application can be filed and the options given are in any patent office in India, only in English, in triplicate, to be filed only in the head office, all of the above and none of the above. Now, herein the answer is A and C, any patent office in India, not only at the head office basically. And for those who thought B as a correct option, we have Hindi as an official language. English or Hindi can be done. So this is as per rule 19. Just go through rule 19. An international application can be filed in any office in triplicate. The Intellectual Property Appellate Board. Now, this is something that I have been repeating in all my sessions or all the question paper answers. IPAB has been dissolved, but IPAB, when it was there, it was a not a statutory body under Indian Patent Act. Indian Patent Act didn't create the IPAB as a statutory body basically. The reason being IPAB was just not only about the patent, but also it had other types of IP which would be appealable to that IPAB basically, right? So A is a wrong option. B, above the High Court and below Supreme Court is also a wrong option. Immune to challenge in High Court is also a wrong option. The correct answer here is a board where the controller has the right to appear before its legal proceedings. The controller can appear there. Actually. This is as per section 117. Question 14. If the stamp of patent pending is used by anyone before the grant of the patent, such an act. Now, this is also in some jurisdictions called as patent marking. So if you see a product therein, or the package basically, therein it would be written patented or patent pending. Now, in that case, now what is asked here is liable for a punishment of rupees 1 lakh, can be proceeded before IPAB, allowed if there is an application pending in India, allowed if there is an indication it has been applied outside India, all of the above and none of the above. The correct answer to this is C and D. If application is pending, then under section 120, anywhere in India or outside, you can put patent pending marking actually, or what you also call as a stamping basically. So when I say marking, so the term generally used is patent marking for putting as a part of a package basically, or the entire I would say external outlook of the product. Therein you are mentioning this. Now, a request for examination for an ordinary application can be filed along with complete spec, anytime before publication, anytime after publication, anytime within 48 months, B or C subject to D, and all of the above. A bit tricky question. I'll just try to explain this. The correct answer is all of the above actually. Because RFE can be filed along with complete spec for sure. Anytime before publication of the complete specification, publication happens in 18 months. Before that, it can be done. Anytime after publication of the complete specification, and B or C subject to D, that is 48 months actually. Within 48 months actually. That is also allowed actually. I think just to correct this, I think it's not A, B, C, D, E, F, but the correct answer should be A, B, D, and E. A, B, D, and E. C and F are not correct. C, I think F is not correct, as well as C is not correct. C may not be correct because C is only subject to D. C as such is not correct. Anytime after publication of complete application is not correct, because it can be after 5 or 6 years as well. So my apologies. I think the correct answer here is A, B, because that automatically happens before 48 months. D and E. A, B, D, and E. C and F are not correct options. So that was about your first part. Now part 2, wherein you have to select you have to select true or false. A model or sample of an invention should be submitted as part of the specification. No, that's a false statement. Under section 10.3, you can submit a model or a sample if required actually, but that would never be part of the specification. Any Indian resident can file a patent in SAARC country before filing it in India. False. Actually, you need a foreign license or foreign filing permission under section 39. 3. Patent pre-grant opposition has to be filed within 6 months of the publication. That's a wrong answer. False actually. It can be filed any time before the grant of the patent, the pre-grant opposition. For post-grant opposition, there is a timeline of 1 year actually. But where is the 6 months coming? I'll tell you. If a patent application is published, and for example, so I have filed a patent application. In the early publication request, it gets published, let's say within a week actually, and FER as well as hearing is done in three months time, let us say. It has happened with us actually. We filed an application in the month of October 2021. February 2022, we are done with the hearing and written submission. The controller has accepted to grant it. Now, in this case, the grant certificate may not be issued before 6 months actually, because that's the timeline given in that case. For after publication 6 months, the patent won't be granted or certificate would not be issued because of the pre-grant opposition. This is the timeline given for the pre-grant opposition. But this statement actually, blanket statement that it has to be filed within 6 months is a wrong. It has to be filed any time before the grant of the patent. A lapsed patent can be restored by filing a case in district court. Absolutely wrong answer. It has to be done at the patent office only. Under section 60, a patent can be restored in a patent office actually, and not at the district court. A patent acquired by the government for public purpose is not entitled for any compensation for the owner of the patent basically. That is also a false answer. Under section 100, subsection 3, if any patent, any property is acquired by the government, then the owner of that patent or the property would be eligible for compensation. In a patent matter, a court can give declaration or injunction against groundless threats, but cannot award damages as a relief. That is also false, because under section 106, the courts can also award damages as a relief to the patentee basically in case of matter of infringement suit, like, you know. Now, any counterclaim in a suit for infringement can be brought before the Appellate Board. Again, I think this was 2011 wherein IPAB was active. IPAB is not active now, but the correct answer to this is false, because the counterclaim in a suit of, so infringement suits basically would be always in the court, and that's the reason under section 104 this is a wrong answer or a false statement basically. The controller has the power to amend the abstract for providing better information to the third parties. Yes, that is correct, and because it happens most of the cases. Why is it also important? Because what you file as a claim may be really very broad, and what is getting granted to you may be very narrow. So the controller can suggest or amend basically the abstract for providing better information to the third party. Question number 9, the controller can issue a compulsory license in case of national emergency, extreme emergency, and public non-commercial use. That's a true answer. This is as per section 84, which speaks about the criteria for the getting a compulsory license basically. Lastly, legal representative of any deceased person who immediately before his death was entitled to make an application for patent. So this is true under section 6 of Indian Patent Act. Any legal representative can apply can apply for the patent basically. So this is about 2011 question paper, paper 1. Very soon we would come up with another question paper, paper 1 in this particular series. We are trying to ensure minimal errors actually in this particular video, but then if you feel like there are any errors, just put it in the comments box of the YouTube channel. We would definitely rectify those if possible in the video, or at least we would put some disclaimer. Thank you so much for joining in, and hope this is something which is useful for your patent agent exam preparation. All the best.